Click the screen, it's time to play. Pam's got the tea and the hot buffet. Movies roll lights flash all day. Time entertainment TV. Where the fun and the facts agree. Sit back, relax, and you'll see. Time entertainment TV. Where the fun and the facts agree. Sit back, relax, and you'll see. Drama unfolds, the plot gets thick. Celebrity cases real and slick. She breaks it down quick as a flick. Where the fun and the facts agree. Where the fun and the facts agree. Sit back, relax, and you'll see. Have entertainment TV.
Good morning, good afternoon, or good evening. This is Pamela, and you are watching Pam Entertainment TV, where we're about to go over the lawsuit that Daystar Peterson filed against the California Department of Correction, plus the correction officers and Danny Samuels, who is the warden. Now, as you all are coming in, please make sure that you all are hitting that like button. And if you're liking what you see, subscribe. It is about an 18-page document. We're not going to read the entire thing, but we are going to go over the high points with this particular document. And if you are interested in my channels, here are my 2 channels. Please make sure that you all subscribe. All right. So how did we get here? So let's remember who Tory Lanez is. Now, Tory Lanez is a Canadian rapper who was living in California at the time. Now the setup, let me just go back to how he got to jail. Now, he went to jail. He's currently serving a 10-year sentence for the shooting of Megan Thee Stallion in the foot. As you all infamously remember, they were out during the time we were quarantined. They start off at Kylie Jenner's house. Everybody is drinking and drinking probably a tad too much. We find out later that Megan and Chelsea were both having relations with Tory Lanez. They all got into this argument in the car. One thing led to another. Megan asked to get out of the car. She gets out of the car. They bring her back into the car. Somewhere, somehow, gunshots hit. Looks like a bullet ricocheted and hit her in one of her feet. And we went to trial. He was convicted. So in December 2022, he was convicted of 3 felonies: assault with a semi-automatic weapon, having a loaded unregistered firearm in a vehicle, and discharging a firearm with gross negligence, which led him to a sentence of 10 years in prison. So now he's in prison. So May of last year, it was reported that Tory Lanez had been stabbed by a fellow inmate. And this inmate is Santino Casio, was 41 years old. He was serving a life sentence for second-degree murder at the California Correctional Institute at Tehachapi. He was identified as a person who allegedly stabbed Tory Lanez 14 to 16 times with a self-made weapon back in May of 2025. Okay, so this is how we got here. When Tory Lanez was stabbed, he was stabbed about 16 times. In the face, in the neck, in his torso, and I think he had a couple in the back. It was very serious. It was a very serious injury, so serious, in fact, that 1 or 2 of his lungs had collapsed at one time. So you're looking at, he could have been gone. All right. So he filed this lawsuit on the 14th of this month, and it is a federal lawsuit. When I initially did my video yesterday, I made the assumption that it was a state lawsuit, but apparently it is federal. So let's go over what he is suing, the complaints that he is suing for. So you have violation of the Eighth Amendment, failure to protect. He is suing under U.S. Code uh, 42, Section 1983, violation of the Eighth Amendment. He's suing for violation of the 14th Amendment, deliberate indifference. He's got two counts of count of negligence against the correction officers. He has a count of negligent supervision and training against the warden and the officers, intentional infliction of emotional distress, violation of the Privacy Act, and conversion. So there's two things in here that we need to talk about what they mean. And so we have here negligent supervision and or training under the Monell policy claim. So what is the Monell policy claim? Now I just Googled it up to see what it was. And it says here that a Monell claim based on Monell versus Department of Social Services from back in 1978 allows individuals to sue local government entities, city, county, police departments under U.S. Code 42, Section 1983 for civil rights violation. To succeed, plaintiffs must prove the violation resulted from an official policy, widespread customs, or deliberate indifference, such as failure to train, rather than just an employee's individual misconduct. So it has to be misconduct from a system. And so what he is saying that he's suing the officers because they failed as a collective to not see that this man was dangerous. He's suing them as a collective because, as he says it, he was a celebrity. He was not supposed to be in the population. He's arguing that he was supposed to be in the celebrity status step where he should not have been in that dorm with this man. And they should have known that this man posed a danger not only to Tory Lanez, but the whole unit on a whole. The other thing that was interesting to me was this conversion. Let's go back and see what conversion under federal California law is. Conversion is an intentional tort involving the wrongful exercise of dominion or control over another's personal property, depriving them of use. Both under federal and California law, it requires proving the plaintiff's ownership, right, or possession, or right to possession, the defendant's wrongful act of control, and resulting damages. It is a strict liability tort, meaning intent to take the property is required, but wrongful intent or knowledge of ownership is not. What is the results? What is he seeking? So here we have, he wants a jury trial. And TMZ reported that he wanted $1 million per stab. And in my last video, when I saw that, before I saw this thing, I was like, oh, so he had 16 stabs. So not only he's suing for damages, he wants $1 million per stab, but it doesn't say that. I think they were just being clickbaity, which is fine. But what he's looking for is compensatory damages for $100 million for the medical expenses, the physical pain and suffering, the permanent facial scarring and lung damage, severe emotional distress, lost earning capacity through his music career, property conversion of 2 songbooks and a legal notepad. He's looking for punitive damages against officers 1 through 50 and the warden for deliberate, indifferent, and outrageous conduct. He's looking for injunctive relief. He wants immediate return of his songbooks and materials. And he wants the California Department of Corrections and Rehabilitation policy reformed for celebrity inmate classification. All right. All right. Let me get to the first page of this. You've seen it, but just so that you can, let me see, share this tab. I like it 160. All right, here we are. You've seen this page. We're not going to belabor it. Let me close this out. All right. So we went over Daystar Peterson, aka Tory Lanez, is the plaintiff, and we went over that Doe correctional officers 1 through 50, Danny Samuel, who was the warden at that particular facility, and the California Department of Corrections and Rehabilitation. And we went over what he wanted. So just real quick, we went over what he wanted. Also, the jurisdiction and venue. He says this court has federal question jurisdiction over plaintiff Peterson's claims under U.S. Code 42, Section 1983, for the violation of his 8th and 14th Amendment rights. Venue is proper in the Central District of California, pursuant to United States Code 28. Section 1391B2, because a substantial part of the event giving rise to the claims occurred at California Correctional Institute in Tehachapi, which lies in the district, this district, and all the people were employed at that particular. So that is the correctional facility in which this happened. He has since been transferred, but this is the correctional facility that happened. And again, we have the parties. He is suing the 50 correctional officers as a John Doe until he can figure out which officer was on duty at that particular time. So he's suing them all until he finds out more information. Once he finds out more information, they will amend this document to show that the proper correction officers who were on duty at this time. He's also another defendant is the warden, Danny Samuels. In which I assume he's currently still the warden at that facility. And as a whole, he's suing the California Department of Corrections. Now, one of the things before you have to do a federal lawsuit is that you have to exhaust all administrative remedies. Now, according to Daystar Peterson, on June the 9th, he submitted CDCR form 602, grievance number 1, regarding the defendant's unlawful seizure and conversion of his original songbooks containing property lyrics, and that's a violation of his privacy rights. And on July 8th, he submitted a second form regarding the May 12th incident where the stabbing attack. He says that CDCR failure to protect improper housing classification with known violent predator, and deliberate indifference to Peterson's safety. Both 602s were timely filed per CDCR DOM section 520 70.5, and CCR, I guess it's California law, section 3084.6. So I guess under California's policy and procedure in prison, he filed two separate claims. Now he filed one claim for his songbooks and notepads, because he says that that it contained proprietary lyrics. And also, now that I'm looking at and remember he also did a couple of songs from prison early 2020. What was it? Early 2023 ish, maybe 2024 ish, if I'm not mistaken. He had done some songs, so he was pulling from somewhere to house those songs. He also filed for the attack on July 8th. Now, according to Daystar Peterson's attorneys, defendants failed to respond to either grievance at any level. There was no response were received within the required timelines, according to CCR Section 15. CCR Code 15, Sections 3084.8. They say that the complete lack of any response constitutes constructive exhaustion of administrative remedies. So no exhaustion required where grievance process is effectively unavailable due to non-response. So that they said they had given them appropriate time. So here we are. They filed in June 9th of 2025 and July 8th of 2025. So that was last year. So they gave them enough time, because remember he had to recover. So they gave them enough time to respond, and according to Daystar Peterson's attorney, they have not responded. It says plaintiff also complied with California Government Claims Act by filing a proper late claim with ORIM on November 21st, 2025, and that was due to prior counsel's resignation, which was deemed denied for non-response within 45 days. True and correct copies of June 9th and July 8th form are claimed here as Exhibit A. So we will go over that as, I don't know if I have that. We'll find it. I'll find it. So let's get to the factual allegation to this cause, and we will read that, because that's going to give us a clear account of what happened on that faithful day. And remember, as you all are coming in, please make sure that you all are hitting that like button. I appreciate it. All right, so we are about to go over this lawsuit. On May 12th at approximately 7:30 a.m., plaintiff Daystar Peterson, and I guess the parentheses is his prison number, publicly known as hip-hop artist Tory Lanez, was unprovokedly stabbed approximately 16 times by inmate Santino Casio using a homemade quote-unquote shank while housed together at California Correctional Institute at Tehachapi. Plaintiff Peterson sustained stab wounds to his back, torso, back of his head, and face that left him with permanent scarring, along with 2 collapsed lungs. He was airlifted in critical condition to Kern Medical Center and placed on ventilator. After his hospitalization, Peterson was then transferred to the infirmary before relocation to California Men's Colony. So he's currently in a separate facility. Peterson was attacked by an individual by the name of Santino Casio, who is an inmate with a violent history. The choice to house Casio with Peterson was known, or should have been known, to have been a danger. Casio is currently serving a life sentence for second-degree murder and attempted first-degree murder for the killing of his 13-year-old pregnant, quote, runaway girlfriend. Now, y'all, this was 20 years ago. And if he's 41 now, 20 years ago, he would have been 21 years old. and she would have been 13. It seems like there should have been some more charges going on. But that's just my from reading what I'm reading. An attempted first degree murder for the killing of his 13-year-old pregnant runaway girlfriend while he was on parole. It was found that Casio inflicted great bodily injury when committing said assault with a deadly weapon. His record, while incarcerated, also is riddled with violent offenses, all which were known to defendants at the time of the housing assignment. So they're basing the fact that this was a dangerous, violent person. That not only Daystar Peterson shouldn't have been housed with him, nobody should have been housed with him. He should have been in a situation where if he's had issues with other inmates in the facility, there's no reason why he should have been housed with anybody in the facility. He should have been at a more secure situation, is what they're saying. Despite Casio's classification as maximum security violent predator and Peterson's high profile celebrity status, this is what he's talking about, which makes him a target, defendants Doe 1 through 50 and Warden Danny Samuel knowingly housed them together, violating California Department of Corrections and Rehabilitation's classification protocols in accordance with DOM 62010.10, which calls for decisions to house together or separate inmates by risk factors. Correctional staff were not immediately present. It is unknown why response was delayed, allowing full attack. This evidence deliberate indifference to foreseeable violence. This evidences deliberate indifference for foreseeable violence. Moreover, despite posted warnings within the CCI, force was not used to protect Peterson. There weren't any flash grenades, smoke bombs, or rubber ammunition expelled to stop Casio from stabbing Peterson repeatedly. As plaintiff Peterson was fighting for his life in the hospital, defendants unlawfully seized Peterson's original songbooks containing unpublished lyrics with substantial commercial value, considering revenues from future streaming and download servers based upon Peterson's past historical charts. These personal books also contain notes between Peterson and his attorney of record. No inventory, receipt, or return has been provided. Defendants' customary practices of understanding improper classification and properly mishandling, where did I go? Constitute policies and patterns supporting the Monell liability. As direct result, Peterson suffered from permanent injuries. It is reasonable to value his damages, considered his celebrity status and earning potential. Here we go. At $1 million per stab wound. Sorry, TMZ, I lied on you. I didn't read that part. I didn't see that part. $1 million per stab wound. $10 million due to facial scarring leading to career harm. $25 million for pain and suffering, along with the property loss of his songbook. Privileged attorney notes, along with emotional trauma, reputational damage, and the ongoing safety risk that Peterson is currently facing, for a total of $100 million in damages. First cause of action: violation of civil rights from U.S. Code Section 42, U.S. Code 42, Section 1983, the violation of his Eighth Amendment rights, failure to protect against Doe, and he's suing the correction officer 1 through 50 and Warden Daniels. And let's see if there's something. So we're going to read just a couple. We're not going to read everything in here. We're just going to read the highlight points, because you can definitely find this court thing on Pacer. At all relevant times, Peterson was defended in the custody of CCI Tehachapi, and I will butcher that, Tehachapi, to which Peterson should have been protected through the cruel and unusual punishment clause of the Eighth Amendment. He's saying that the correction officers and Warden Danny Samuels acted with deliberate indifference to plaintiff Peterson's safety by knowing housing Peterson with inmate Santino Casio was a maximum security violent predator with multiple prison weapons conviction. They're saying that they mismatched and that they were keenly aware that inmate Casio was not only he was going to be a threat to other inmates because, number one, he came in on a very violent crime, recruiting from a 13-year-old from the timeline, and subsequently had been fighting with other inmates, which by myth and lore would have been the issue because of the fact that it looks like during his jacket he unalived a child. So I don't know what kind of conversations him and Daystar had. Excuse me. I don't know none of that. But Tory Lane's attorneys are saying that they should have known between the two of them that they were a mismatch. And that they didn't follow proper protocols to match Casio with the appropriate inmate. The substantial risk of serious harm from housing plaintiff Peterson with inmate Casio was obvious. A deliberate indifference exists when prison officials know and disregard excessive risk to inmate health and safety. That's obvious, even if not specifically known. So they're saying that Casio has made considerable weapons before and have injured other inmates before. It was reasonable to assume that, or at least you should have been having more people check between Peterson and Casio, because Casio was known. He was a known offender of all of this. Defendant had actual knowledge of Casio's extreme violence through the CDCR Strategic Offender Management System database, documenting Casio's life sentence for murdering a pregnant teenager, multiple prior convictions for assault with a deadly weapon, coupled with great bodily harm enhancements, prior prison weapons violations. The classification committee record, pursuant to California Civil Records, I think I'm gonna look that up what it means. Pursuant to that, required quarterly reviews that flagged Casio as close A maximum custody and noted his pattern of targeting vulnerable inmates in the past, with the most recent violation just 90 days prior to the attack on plaintiff Peterson. So 90 days prior to him stabbing Daystar, aka Tory Lanez, he had violated someone else. Warden Samuel's direct oversight of CCI's sensitive need yard policy meant to separate celebrities like plaintiff Peterson from violent predators like Casio. Yet defendants proceeded with co-housing, demonstrating subjective reckless disregard of the obvious danger. Defendants disregard the known risk and failed to monitor and or adequately supervise after such a dangerous housing choice, which directly caused plaintiff Peterson stab wounds, collapsed lung, permanent facial scarring, critical life-saving hospitalization, and ongoing trauma. Defendant's conduct shocks the conscience and constitutes cruel and unusual punishment in violation of the Eighth Amendment. So then you have the second cause, which is violation of civil rights, deliberate indifference against Doe Correction Office 1 through 5, and Jordan Samuels. We won't go back over that, but basically they deprived the plaintiff's right to due process and right to bodily integrity. The 14th Amendment opposes substantive due process obligation on state actors to protect prisoners from state-created dangers. Defendants created or enhanced the danger by choosing to affirmatively place high-profile plaintiff Peterson with the violent predator, despite the clear red flags. So I highlighted that the defendant's failure to act demonstrates a severe, deliberate indifference to plaintiff Peterson's constitutionally protected liberty, interest in personal safety and bodily integrity. So basically, they said that they had a rule book. They knew what to follow. They have a situation where they do classify or they do have separate wards for people who have celebrity status. And because he had celebrity status, he should not have been in the section with Cassio in the first place, particularly if you knew that he just had a violation 90 days before. Why wasn't he moved off the unit? Why wasn't Cassio moved off the unit and placed in a separate unit, a more secure unit? Or why wasn't Daystar Peterson placed in a unit for celebrities? They have protocols for that because they've had several celebrities placed in jail for various reasons. By failing to separate plaintiff Peterson from that known threat, then failing to provide meaningful supervision and failure to intervene before the attack escalated, defendant affirmatively exposed Peterson to a foreseeable assault that resulted in catastrophic physical injury, permanent scarring, and continuing psychological harm. That conduct was not a mere lapse in judgment. It was a conscious disregard of an obvious danger to Peterson's safety and physical integrity. The constitutional right to personal safety in this context was clearly established. And they list the Kennedy versus City of Ridgefield, which recognizes that state actors may be held liable when they create or fail to protect against a known danger to bodily security. Y'all, please make sure you hit that like button. And if you'd like to subscribe, there's a QR code up at the top that you can hit. It'll take you just to the subscribe page. Also, I have second channel, which is PETV. And I apologize for the coughing and the sniffling because my allergies are not playing today. Let's continue. Third cause, negligence. All defendants. So plaintiff realleges and incorporates what he put through on section 1 through. So that was his description of the incident. Government Code 844-6D expressly waives sovereign immunity for public entities and employees when injuries result from failure to summon immediate medical care, failure to control riotous conduct, or 3, an employee's failure to protect a prisoner from injury by other inmates. This statute creates a special duty of care owed to prisoners who are wholly dependent on correctional staff for their safety and security. Because remember, they try to give more fancy terms, say that prisoners are wards of the state, but technically they are legalized slaves. One moment. Good morning. He says, free Tory. I can't pronounce your name. Shah Zaybak Khalid. Okay. He says, free Tory. But let's continue. So where were we? Said defendants breached this duty through a failure to follow regulations for such a situation, which resulted in improper housing classification. This series of substandard decision making placed plaintiff Peterson with maximum security predator Casio, despite his known violent history. When coupled with the additional failure to supervise and or monitor the housing unit, it created an opportunity which allowed this unprovoked life-threatening attack. Defendants breached their duty of care through multiple negligent acts. They talked about the delayed emergency response, permitting multiple stab wounds across most of plaintiff Peter's upper body. Now, if you saw my picture that they had or the video that was present, I believe it's on TMZ's website, you see that Tory Lanez is upstairs. I guess that's where the beds and things are. You see him, because I'm confused of whether or not that they were sharing a bed together, a cell together, or were they sharing just the communal areas? But you see him come from upstairs. You see him struggling, and then you see him fly down the steps. He's bloodied. And you see the other guy kind of start walking down the stairs. And it wasn't until I guess he had made such a commotion downstairs with table, then the guards came in. But by the time he was doing all of that screaming, I assume he was doing a lot of yelling and screaming. And as he was coming down the stairs, the response time to me from any security guard should have been quick. But we didn't see the security guard because, like I said, we were just watching on the camera. He had enough time to come from up the stairs, run down the stairs, then kind of slowly walk. He looks like he was trying to get someone's attention, and he was walking towards wherever he was walking, because the camera couldn't show where he was walking. It was a stationary camera. But it appears by the time he had gotten down the stairs, it looked like someone should have at least been toward the stairs or walking towards him. We didn't see that. Now I wanted to be clear that from the video that we saw, I can't tell you if it was doctored or not, but it didn't appear it appeared that all of this kind of happened over a period of 3 to 4 minutes. Due to Peterson's high public being publicly known as Tory Lanez, a record-holding music artist, said injuries are critical and have caused severe emotional harm. Moreover, the housing unit was chronically understaffed. Uh-oh. Correctional officers were not stationed at immediate vantage points, allowing Casio unprovoked attack. Despite plaintiff Peterson's critical condition with collapsed lungs and voluminous blood loss, responding CDCR staff failed to immediately summon life flight medical transport, exacerbating Peterson's injuries. They're saying that they didn't immediately take him to the doctor or the emergency room for those injuries, which resulted that I think he went to the infirmary, and it resulted that he had a collapse. His lungs started to collapse. Now, again, I'm no medical person, but we all have watched ER or one of those medical shows showing that the signs of what's going on, that someone's lung is collapsing with the bubbles in the blood and all of this other stuff. Additionally, and importantly, defendants herein acted negligently in the handling of plaintiff's personal property as he recovered from his life-threatening injuries. The loss of Peterson's two personal notebooks with unpublished materials for his professional endeavors, along with notes from conversations with his attorney, violated his right to privacy and stripped him of his property without due process as mandated. Because remember, once the incident happened, he was no longer going back to that facility. He went to an infirmary, and then he was placed in a new facility, which I think was like 200 or 300 miles away from that facility. Let's get to the fourth cause of action: negligent supervision and training under the Monell policy claim. It says why they're liable. In 45 goes back over the incident. 46 says why they're liable under U.S. Code 42, Section 1983, Monell versus Department of Social Services, and that's a case back in 1978. And we went over the Monell policy claim. Defendant California Department of Corrections and Rehabilitation maintained policies and customs that included, but were not limited to, inadequate inmate classification, which ignored violent histories and celebrity status risk, chronic understaffing of housing units, and failure to enforce DOM Section 62010.10 separation protocol. So they have a protocol in place, but they did not use it, according to what the Daystar Peterson's attorneys have written. With the lack of response and intervention to such a severe and violent situation, there plainly is a need for training on protecting high-profile inmates from known violent repeat offenders. Warren Danny Samuel is a policymaker. He failed to train and or supervise officers on recognizing Close A maximum custody risks, such as housing plaintiff Peterson with Casio. So basically what he's saying is the warden is a policymaker. He's the one in charge of the facility. There's supposed to be, because again, California has a lot of high-profiled prisoners, that there is supposed to be in place for those prisoners that are high, because you remember who is high profile out there? Probably several rappers and things like that. But I do remember, you remember that actor who pruned his wife from the timeline? What's his name? Jace. I think his last name was Jace, and he's doing a life sentence for her murder. Then you have that Spectre guy who pruned from the timeline his girlfriend. He is a high profile celebrity. You got Suge Knight that's in there. He's considered to be a high profile celebrity. And I know the list goes on and on and on and on, and I don't have the records of all these people. What's the guy's name on that 70s show? He's housed in the facility. So there's a lot of people. So all I'm saying is that the California Department of Corrections and Rehabilitation, they have some level of protocol, whether it's written or oral, on how they handle and classify a prisoner, whether they're high profile or what have you. They have the ability to classify that, and they're saying that they neglected that. They neglected that either by ignoring or lack of training. And they're saying that because Warden was the policymaker, he was responsible making sure that his officers, that he was staffed correctly, and that his officers had the appropriate training. The fifth cause of action: intentional infliction of emotional distress against all of the defendants. And again, they talked about Defendants were responsible for housing plaintiff Peterson with a known violent repeat offender against regulations and policy, and then expanding the risk of harm through a failure to supervise, which was their duty. As a direct result of said attack, I'm reading number 55, plaintiff Peterson suffers from ongoing emotional and mental damages, which are natural after such a violent near-death experience. Moreover, Peterson lost the value of his property and reputation. Due to the outrageous conduct of defendants, plaintiff Peterson is entitled to all compensatory damages with the addition of punitive damages as appropriate. The sixth cause of action: violation of privacy rights. See, he's going over through this that while he was recovering in the infirmary, that they seized his original songbooks that he had, and also his protected writings to his attorney, and he has not received them back. Because remember, he in June 9th, 2025, he filled out the appropriate paperwork for getting those said items back, and he did not get said items back. Give me one moment. Give me one. I'm pulling up the attachments. All right. And as you all are waiting, y'all make sure y'all hit that like button. All right. I got what I need. Let's get back to what we were doing. The failure of the CDRC to follow their own property regulation pursuant to 15 CCR section 3190 requires documented handling of said property in return. The two songbooks contained highly personal and unpublished lyrics central to plaintiff Peterson's identity as a hip hop artist publicly known as Tory Lanez. These materials should have been protected from disclosure under privacy rights stemming from our highest laws of the state of California. Unauthorized seizure and retention constitutes an intentional privacy intrusion with no legitimate peniological interest, directly harming plaintiff's artistic expression. So they're basically saying there's no reason in the world that anyone in the prison system should have access to his lyrics and to his notes to his attorney. There's no reason in the penal system for anyone to have that information. I thought all of that could have been solved, I hope he labeled everything as notes to his attorney. All right, seventh cause of action, conversion. Plaintiff, section 62, Plaintiff Peterson was the owner of original songbooks containing unpublished lyrics with substantial commercial value. Remember, he was dropping music while he was back behind bars. What was it, 2024 or possibly 2025? Because I know he did something with I can't think of that artist's name, and don't hold me to it. Says he lost for future income through streaming revenue and performances and downloads without due process. Because you remember, he had, like I said, he had recorded a song with some artist, and I can't think of who it was. Oh, who was that artist, y'all? I think it was back in the end of 2024, because I think it was all around. You remember when Kendrick and Drake were doing the rap battle? It was somewhere in there. He decided that he was going to put his name on the thing. Defendants intentionally exercised dominion over Plaintiff Peterson's 2 songbooks by wrongfully seizing them on May 12, 2025, after Peterson was airlifted to the hospital with multiple stab wounds and a collapsed lung without legal cause. Pursuant to CR Section 3094, was required to provide an inventory and receipt of said materials in such a situation. And it talks that he did his grievance form dated June 9th to get his songbooks back. And so far, he hasn't done that. And again, we will go over the prayer for relief. They want a jury trial. They want compensatory damages of $100 million for physical pain, medical expenses, permanent facial scarring, severe emotional distress, lost earning capacity through his music career, property conversion of 2 songbooks, and legal notes. Punitive damages against officers 1 through 50 and Warden Samuels for deliberate indifference and outrageous conduct. They want immediately relief. Their injunctive relief, they want their songbooks returned, and they want policy reform for celebrity inmate classification. All right. That is a suit. Let's see where we are on time. We're doing good. We've got another 30 minutes. So let's go over and look at so here is let's share this tab. This is the ORIM 006 government claim form. And up at the top, they filed this with the court, Department of General Services. It's listed Daystar Peterson, inmate classification, the attorney that's representing them. So I guess this is the claim. It says here under the claim information, it says former counsel working at another firm was responsible for filing this claim. Unbeknownst to undersigned attorney, counsel resigned from the firm prior to filing. As soon as the undersigned attorney realized such, she immediately and diligently pursued this cause of action. All other grievances are filed as required. $1 million per stab wound, $1 million for other wound, $2 million for scar on face, $25 million for pain and suffering. Mr. Peterson was stabbed a total of 14 times with additional cuts. This includes 7 wounds to his back, 4 to his torso, 2 to the back of his head, and 1 to his face, causing a scar. Both of his lungs. Peterson is a hip hop known artist, as Tory Lane. His face and his lungs are imperative for him to perform. Peterson was in critical condition and was airlifted to a hospital and admitted. After approximately 12 hours, he was breathing on his own without the use of a machine. He was in the hospital for 2 days, then transferred to the infirmary. And they just go over the claim. I guess this is a form that they need for California to notify them of the lawsuit that they had. And they filed this on the 14th as well. Let's get to the next one. This is a statement for government claim form. It says who is being filed against, why the application was delayed. It talks about the amount of damages. I'm just skimming through it to make sure that there wasn't anything that we hadn't covered in the lawsuit. Circumstances that led to damage or injury. So this gives a little bit, I think it gives us a little bit more explanation. Inmate Santino Casio launched an unprovoked attack using a self-made shank. Mr. Peterson was partially protected by his hooded sweatshirt, which allowed him to pull his arms inside and create space between the weapon and his body as best he could. Casio is serving a life sentence for second-degree murder, attempted first-degree murder, use of a deadly weapon, and inflicting great bodily injury arising from the killing of his 13-year-old pregnant runaway girlfriend while he was on parole. While incarcerated, he has also been convicted of assault with a deadly weapon and separately for possessing and manufacturing a weapon in prison. Mr. Peterson is a target for attacks within the prison system due to his celebrity status. And where have we heard about the killing of a 13, 14-year-old quote-unquote girlfriend? Child, a mess. So this is a copy of the form that, let's see if we can make this bigger. So this is the grievance form, the 6021 that looks like Daystar Peterson filled out. And I'm trying to get the date. We probably won't see the date. This is the one where he filed for his property. Here we go down here at the bottom. We've got the June 9th, 2025 date. So this is the first form that he filled out, that he wanted his property. And here is just the second page to that particular, that June 9th, where he writes it out. Let's see what he wrote. Excuse me. This is what he wrote. I noticed an abundant amount of missing items. Various electronics, clothes, and more were missing. On top of this, I never received any of my food. However, this 602 is about the missing documents out of my paper holding bin. I noticed specifically that both of my main music books, full of my intellectual property and legal documents. It should be noted that these books specifically are worth millions of dollars. I've made a citizen's complaint about the staff of CCI multiple times. It should be noted that when I was stabbed 14 times, the facility staff did nothing to stop me from losing my life. It should be noted that the video of me getting stabbed was also sold and exploited to TMZ without my consent. Well, baby, you know, when you're in prison, you are considered to be a slave. But let's continue. Not to say that you don't have rights, but those the surveillance videos don't belong to you. So, but you can sue for grievance if it's causing you some harm. The documents missing out of my property are worth money and further attest to the fact that I was set up by the CCI facility staff. So he believes he was set up. And the attempt of assassination on my life could very easily much been a plot to steal my intellectual property, which is and has been proven to be worth millions of dollars. This has interfered with my mental health. I now have PTSD and don't have any faith or integrity in the officer's place. It should be noted that CCI facility staff packed my property and have all control of where it was delivered and how it was handled. This level of harassment, theft, and unethical conduct needs to be investigated further. So then we go into the document of when he complained about the attack. As documented on paper and camera by CCI facility on May 12, 2025, excuse me, I was the victim of attempted murder. My complaint is against the facility staff. I was stabbed 14 times during the stabbing as documented on camera. The facility staff stood there and watched. They did not do any of the correct protocols. They did not approach the incident to stop. Many physical things. He says, what can't you do? What's the problem? When they ask for his reasonable accommodation. He said many physical things. Mental skills that I once had are unattainable due to the PTSD and trauma my brain experiences now, and much more. He says that the facility failed to do their job, causing me to almost lose my life. To exhaust my remedies to take this to a higher court. And let's see, this is the second page of that document, and we will be through, y'all. So he says here, incidents from proceeding, they did not spray any pepper spray. They did not throw any smoke bombs, despite the numerous signs on the building wall saying, we'll shoot if lethal force is being used, if legal force is being used. They did not shoot any block guns or use any force to stop me from losing my life. This has affected my mental health in a major way. I now have a lot of PTSD about the cops in CDCR. This grievance is not about the attack or my attacker, as I have decided not to testify against him. This grievance is about the blatant misconduct of the officers and facility staff. As I was bleeding out and waiting for medical to arrive, I looked out of the window in the front door in the rotunda and spotted medical walking, not running, in the distance. I asked the floor cop to radio them to come faster, as I felt I was about to die because both of my lungs were collapsed. The cop doesn't do what I asked, but proceeded to yell, "Get down," as if I wasn't already down on the floor. This misconduct and neglect almost costed me my life. A very expensive life. As if shared to be noted that I am an A-list celebrity. Now, Tori. B++ at most. It should also be noted that another inmate named Daryl Foster wrote a 602 about this on my behalf. Okay. What are y'all thinking? Do you think he has a case? Do you think the correction officers were negligent? It appears that he has a good case, particularly knowing that they had him housed with a guy who not only 90 days should have been in oh, I don't know what cause of action they did for that man, the Casio man. But if the people on the unit were complaining about Casio, that's going to be interesting. Don't know if they're going to say anything, due to the fact that, Casio is still in the prison. If I remember correctly, there was some gang ties, if I remember correctly. And this man has already proven that he don't give, if y'all don't give a F, he don't give a damn. This is straight craziness. All right, people. What are y'all thinking? This is a lot. And like I said, I think he has a case. Let's see what happens. Let's see if they settle, see if the department settles or not. I don't know what they're going to do with his property. Do they still have his property? Because that's been over. It's almost been a year now. What did they do with that property? Did they sell it? What did they do with it? The world may never know. Because he doesn't have it. And it's almost a year since the incident. It's a month shy for the year, and he claims he still doesn't have. He claims he still doesn't have it. So we will see. We will see. All right, people. We made it just under an hour and a half, which is wonderful for me. Which is also wonderful for the algorithm. So you don't have to. You could fast forward. You could put it on 1.5 and 2 times the speed and watch it. This has been informative. Y'all make sure y'all hit that like button and also subscribe. Y'all please tell a friend. That was the Daystar Peterson versus the California Department of Correction and Rehabilitation Services, and the 1 through 50 officers that were on schedule when this incident happened. Let's see what results from this. He's asking for $1 million per stab wound and $10 million for his facial scar. So it's got to be substantial, because we haven't seen Daystar Peterson we hadn't seen him since the stabbing publicly. So I'm quite sure they did not do any adequate plastic surgery or anything like that. So he probably has a real substantial scar. And again, he's not due to be out of prison for 10 years. So he still has, what has he been there since 2020? The end of 2022? So he's been in prison for like 3 years. And he probably has another 6 years, another 3 more years for good behavior. Now, I don't know how California does their sentencing guidelines, because some people say that if you get time shaved off for good behavior, so I'm quite sure he's been keeping a low profile since the stabbing last year, and this may be a safety issue, so they may tack off some time for that. But it is my understanding, since he's not an American citizen, once he gets out, I don't know if California is going to do interstate compact or intercountry compact and have him go back to Canada, or have him go to Florida, because I think his father is in Florida. But I think his visa has run out. So he may end up having to go back to Canada. I don't know. But either way, he is going to be suing. Please tell a friend, tell a kin, tell a coworker, tell that heifer that you can't stand that I'm over here making these videos. And as always, people, bye-bye.